Let's talk about 5 mistakes that people have been making recently at their marriage-based green card interviews. So the first one is something that I recently came across with one of my own clients, and that is that USCIS officers will sometimes ask to see your text message conversations to each other, to the other spouse. And in the example that I'm giving you, the immigration officer asked to see the text messages, and after scrolling along, realized that there was something suspicious in the texts, and then immediately separated the 2 spouses and conducted separate interviews with each one. Now, we have yet to see what the outcome of this is. I still think the case is going to end up getting approved, but that's a warning for everyone else out there. Make sure that if you bring your cell phone and the immigration officer asks to see your text messages are consistent with everything that you're telling the immigration officer, which of course needs to be the complete truth. Another mistake I see people making at these interviews is they get confused by the interview appointment notice, which has a whole section about the I-864 affidavit of support. It'll say things like bring pay stubs for a couple months, get a letter from your employer, if necessary, submit the affidavit of support and tax returns. When I prepare people's cases, I tell them you can ignore all of that. All you need to do is bring your updated tax return, assuming that the petitioner, the US citizen spouse, is the only affidavit of support sponsor. If you use the joint sponsor, you also need to bring the joint sponsor's tax return. And when I say tax returns, I'm referring to the most recent tax year. So right now we are in July 2025. The most recent tax year would have been the 2024 tax return. That's Form 1040. That's the IRS tax return form with all federal schedules, W-2s, and 1099s. Some people might not have federal schedules or 1099s. They might just have the simple 2-page tax return with a W-2. That's okay if your income requirement is high enough. Another thing, now that we're talking about affidavit of support, and I've done videos on this, you don't need to provide evidence of assets unless your income is too low. So just keep that in mind. You don't even need to fill out that part of the affidavit of support form. Just make sure when you attend the interview, you bring updated tax returns for any affidavit of support sponsors. A big mistake that I see a lot of people make is submitting bank account statements that don't have a ton of real transaction history. I'm not saying you should open a joint bank account and then manufacture a bunch of transactions so that you have evidence for your immigration interview. Actually, I'm not saying that at all. When I tell people during our initial consultation or when we are preparing the case is, if you guys have a joint bank account or you plan to open a joint bank account, be sure you use it. Otherwise, it's not really good evidence for immigration purposes. And by the way, you don't have to have a joint bank account. If the immigration officer asks you guys, do you have a joint bank account? And you say no, and then the immigration officer asks why, you can explain why you don't have a joint bank account. And that reason is different for every married couple. It might be that you don't want to increase the chances of getting divorced by mixing your finances, which is a real thing. You guys just feel more comfortable having your accounts separate. Or you just haven't gotten around to opening a joint bank account and you're using your separate bank accounts for now. That's fine. The immigration officer might ask follow-up questions like who pays for the rent, who pays for the utilities, who pays for your groceries, which bank accounts are those coming out of? Do you reimburse each other? What's your financial situation like? You don't have to have a joint bank account. But if you do submit a joint bank account as evidence, you need to bring statements, updated statements to your interview. And if your bank account statement only has like 2 transactions each month, I would rather you not even submit that as evidence of a good faith marriage. I would advise you to bring those statements with you to the interview. And if the immigration officer asks, do you have a joint bank account? You should say yes, but we don't really use it. We were hoping to use it more, but we didn't get around to using it that much. So we didn't plan to submit it as evidence of our joint marriage, but we did bring copies of the statements. And we also brought copies of our personal bank statements showing which expenses we individually pay for and how we've reimbursed each other if you reimburse each other. Another thing that a lot of immigration officers like to see are the spouse's driver's licenses. They want to see that you guys have driver's licenses listing the same address. And I can't tell you how frequently I speak to people and they're like, well, we just never got around to updating our driver's license. Or the US citizen will sometimes say things like, my driver's license address is just my parents' house. That's what it's been my whole life. I don't want to update it. I get that. You can explain that to the immigration officer, but it's much better for you guys to have driver's licenses that are updated, listing the same address. And this is particularly important if you don't have other evidence that you're living together. For example, you don't have a joint lease agreement because you're living at your friend or family member's house, or one of the spouses owns the home and just had a mortgage going before you got into this marriage or started this relationship, and you just don't want to change the mortgage documents around for practical reasons. That's fine, but you need some evidence that you guys actually live together. Driver's licenses are great. You can have renter's insurance or homeowner's insurance listing both spouses, or otherwise just a ton of evidence showing you guys both receive mail at that address. The final mistake I see a lot of people make is not preparing enough for the interview with an attorney and then just hiring an attorney to attend the interview with you. I don't think it's enough to just bring an attorney with you to the interview if you don't prepare. In fact, I don't even think bringing an attorney with you to the interview is going to change the outcome. I think preparing with an attorney before you attend the interview is much more important than physically bringing an attorney with you, which I many times just view as a money grab and unnecessary. Because, let's say you go to the interview. The reason why people want to bring an attorney is because they're afraid that they might get detained at the interview. Well, if you're going to get detained at the interview, the attorney's just going to watch you get detained at the interview. They're not going to be able to really stop the process. There are some times when having an attorney there is super helpful. For example, if there's a criminal issue that the USCIS officer might not understand, like the officer might think this crime makes you ineligible for residency, an immigration attorney being there might help avoid an unnecessary request for evidence or notice of intent to deny, or a mistaken denial of the case when the client is eligible. An attorney can also escalate the interview to a supervisor if the immigration attorney is just asking inappropriate questions. An example that I'll give you is I've heard of a specific immigration officer having problems with same-sex marriages and saying inappropriate things that go so far as, like, I don't even believe same-sex couples are in a real marriage. I don't believe that's a real thing. Like, if an immigration officer says that, that's clearly super inappropriate, and having an attorney there can escalate that to a supervisor so that you can at least get a different interviewer, and it could help you avoid problems with getting a Stokes interview, which is a fraud interview, or just getting your case denied because the immigration officer was prejudiced or is otherwise behaving inappropriately. My general position, and this will remain true until I have enough information to change my mind, which I do reserve the right to do in the future, I don't think most people actually need an attorney present with them at the interview. I'm not judging if you want an attorney there. I get it. There's a lot of crazy stuff going on, but I think it's much more important to prepare with the attorney. If you have a straight up simple case, which for me would be visa overstay, no criminal history, no multiple entries after you overstay, no history of immigration fraud, everything is pretty straightforward. The only problem here is visa overstay and maybe some unauthorized employment, which the majority of my marriage cases probably fall into this hypothetical fact pattern that I'm describing. Those cases don't necessarily need an attorney present at the interview. Nothing wrong with having an attorney there, but it's not going to change the outcome. And in a lot of cases, it's probably a waste of money. All right, guys, so those are 5 mistakes I think a lot of people have been making recently. If you want to speak with an attorney about your case and get some honest advice from someone who's not trying to sell you on any services, just trying to give you the best bang for your buck, the best value for your time, for your paid consultation, you can schedule a consultation with me. My information is in the video description below. I will promise you that you will get honest advice during the entire time and that I'll never try to sell you on any services that you don't want. If you want to learn more about family-based immigration, be sure to subscribe to the channel. I put out 5 videos each week, and I'll see you guys next time for another video.